Perjury, Part 2. But if the testimony of such a witness is corroborated by very strong and independent circumstances regarding the other, reliance might then be placed on the witness for convicting the other accused. Muhammad Ahmad and another versus the state and others 1997 SCMR 89. Needless to point out that it is by now a settled proposition that the maxim falsus in uno, falsus in omnibus has no universal application, and not unoften the grain has to be sifted from the chaff. Refer Kheru and another versus the state 1981 Supreme Court 1176. Nazir Ahmad alias Nazira versus the state 1998 SCMR 1768. Falsus in uno, falsus in omnibus, false in one, false in all, is no more operative, and the rule of sifting the chaff from the grain is to be applied while apprising the evidence in criminal cases. Sardar Khan and three others versus the state 1998 SCMR 1823. The maxim falsus in uno, falsus in omnibus has not been accepted by the superior courts in Pakistan as having universal application. Therefore, it does not necessarily follow that where the court does not accept the evidence of a witness against some of the accused in a case, the court cannot accept his evidence against the other accused. The court often sifts the grain from the chaff while accepting the evidence of a witness against some of the accused in a case, and at the same time not relying on his version against other accused in the case. See Muhammad Ahmad versus State 1997 Supreme Court 89 and Kheru versus the State 1981 SCMR 1176. Mir Hassan and others versus state and others 1999 SCMR 1418. In the case of Sardar Khan versus state 1998 SCMR 1823, this court stated the following broad principles for appreciation of evidence while deciding the cases involving capital punishment. The maxim falsus in uno, falsus in omnibus has not been accepted by the superior courts in Pakistan as having universal application. Therefore, it does not necessarily follow that where the court does not accept the evidence of a witness against some of the accused in a case, the court cannot accept his evidence against the other accused. The court often sifts the grain from the chaff while accepting the evidence of a witness against some of the accused in case, and at the same time not relying on his version against other accused in the case. See Muhammad Ahmad versus State 1997 Supreme Court SCMR 89 and Kheru versus State 1981 SCMR 1176. Havan Baksh and others versus the state and others PLD 2000 Supreme Court 1. The principle of falsus in uno, falsus in omnibus would not be applicable to their case because of availability of sufficient corroboratory material against them. The rule about the invisibility of the testimony of a witness is that ordinarily, if he is found to have falsely implicated an accused person, he should not be relied upon with regard to the other accused in the same occurrence. But if his testimony stands corroborated by strong and independent circumstances regarding the other, the reliance might then be placed on him for convicting the other accused. The courts are required to separate grain from the chaff by considering whether the same tainted evidence stands corroborated from some independent and strong circumstance or evidence. The following cases may be cited where the circumstances in which the principle of falsus in uno, falsus in omnibus, and its applicability in Pakistan in different situations was elaborately discussed. Tawaib Khan and another versus the state PLD 1970 Supreme Court 13, the state versus Mushtaq Ahmad PLD 1970 Supreme Court 418. Third, Muhammad Shafi and four others versus state 1974 SCMR 289. Fourth, Aminullah versus the state PLD 1982 SC 429. And fifth, Muhammad Nawaz versus the state 1984 SCMR 190. Rashid Khan and another versus the state 2000 SCMR 851. In any event, the contention cannot prevail as the maxim falsus in uno, falsus in omnibus does not hold the field anymore, having been replaced by a more rational methodology of evolution of evidence called sifting grain from the chaff. Reference in this context may be made to the judgments of this court reported as Tawaib versus State, PLD 1970, Supreme Court 13, and Samano versus State 1973, Supreme Court SCMR 162. The testimony in question can be safely believed vis-a-vis the appellant as it is amply corroborated by his aforementioned admission. Sarfraz alias Sappi and two others versus the State, 2000 SCMR 1758. The proposition of law in criminal administration of justice, namely whether a common set of ocular account can be used for recording acquittal and conviction against the accused persons who were charged for the same commission of offence, is an overworked proposition. Originally, the opinion of the court was that if a witness is not coming out with the whole truth, his evidence is liable to be discarded as a whole, meaning thereby that his evidence cannot be used either for convicting accused or acquitting some of them facing trial in the same case. This proposition is enshrined in the maxim falsus in uno, falsus in omnibus, but subsequently this view was changed, and it was held that principle enshrined in this maxim would not be applicable, and testimony of a witness will be acceptable against one set of accused, though same has been rejected against another set of accused facing same trial. However, for safe administration of justice, a condition has been imposed, namely that the evidence which is going to be believed to be true must get independent corroboration on material particulars, meaning thereby that to find out credible evidence, principle of appreciation of evidence such as sifting chaff out of grain was introduced as it has been held in the cases of Sayyid Ali Pepari versus Nibaran Molla and others, PLD 1962 SC 502, Tawaib Khan and another versus the State, PLD 1970, Supreme Court, Bakka versus the State, Supreme Court 13, Bakka versus the State 1977, SCMR 150, Khedu and another versus the State 1981, SCMR 1136, Ziaullah versus the State 1993, SCMR 155, Ghulam Sikandar versus Mamraz Khan, PLG 1985, SC 11, Shahida Raza and another versus State 1992, SCMR 1647, Irshad Ahmed and others versus State and others versus State and others, PLD 1996, Supreme Court 138, and Ahmed Khan versus the State 1990, SCMR 803. Kutubuddin versus the State, PLD 2001, Supreme Court 101. As far as the principle of falsus in uno, falsus in omnibus is concerned, it has got no application so far as criminal justice prevailing in this country is concerned. However, the courts are empowered to scan the evidence to reach at a conclusion as to whether the evidence furnished by a witness can be believed simultaneously against one set of accused and can be discarded against the other set of accused, however subject to independent corroboration or particular point qua the accused against whom such evidence is to be believed. In this behalf, any authority is needed. Reference can be made to the case of Ghulam Sikandar and another versus Mamraz Khan and others, PLG 1985 SC 11. Relevant para from the above judgment is reproduced here under. It is often said that the principle falsus in uno, falsus in omnibus is not applicable in Pakistan. The same principle has been described in some cases slightly differently, namely that the testimony of an eyewitness should not be treated as indivisible, although there is no consensus with regard to the later view. A contrary view has also been held, expressed in a more direct manner. A similar rule in the administration of criminal justice, which is hallmark of Islamic jurisprudence, that when a witness has been found false with regard to the implication of the accused about whose participation he had deposed on oath, the credibility of such a witness regarding involvement judgment of the other accused in the same occurrence would be irretrievably shaken. However, as a matter of convenience, a rule has been developed in Pakistan since the famous case of Ghulam Muhammad versus Crown PLT 1951 Lahore 66, propounded by late Chief Justice Muhammad Munir, that where it is found that a witness has falsely implicated one accused person, ordinarily he would not be relied upon with regard to the other accused in the same occurrence. But if the testimony of such a witness is corroborated by very strong and independent circumstances regarding other, the reliance might then be placed on the witness for convicting the other accused. For further and practical application of this rule, the following cases can be instructive, particularly if the principle of indivisibility of credibility laid down in the Privy Council case Muhammad Faiz Baksh versus the Queen PLD 1951 1959 PC 24 is to be ignored. Twaib Khan and another versus the State PLD 1970 SC 13, the State versus Mushtaq Ahmad PLD 1973 SC 418, Muhammad Shafi and others versus the State 1974 SCMR 289, Bakka versus the State 1977 SCMR 150, Kheru and another versus the State 1981 SCMR 1136, Ahmad etc. versus the State 1982 SCMR 1049, Aminullah versus the State PLD 1982 SC 429, and Muhammad Nawaz versus the State 1984 SCMR 190. It is to be emphasized that the sub-rule of separating the grain from the chaff has been demonstrated in many cases by applying the sure test whether the same tainted ocular evidence has received corroboration from independent and equally strong inculpatory evidence or circumstance or accused. The afore discussed main rule shall suffer serious change if and when it is examined in the light of the Islamic principles. But for the same time being, even if the rule generally followed by the superior courts is applied to this case, it would be very essential to seek strong and independent corroboration against each one of the accused on account of various reasons discussed in the High Court judgment as also in this judgment. No such corroboration is forthcoming against Khan Beg and Maqbool Ilahi. Therefore, maintaining their acquittal on this ground alone would be amply justified. The above view has been followed in the cases first Kheru versus State 1981 SCMR 1136, Muhammad Ahmad versus State 1997 SCMR 89, and Mir Hassan versus State 1999 SCMR 1418, Anwar Ahmad and another versus the State 2001 SCMR 1518. We are also of the view that principle of law, falsus in uno, falsus in omnibus, is no longer accepted by the superior courts of this country, and the court is under a duty to sift the chaff from the grain and find out as to whether a part of the evidence is reliable and confidence inspiring. Muhammad Zubair and another versus the State 2002 SCMR 1141. It would not be out of place to mention here that maxim falsus in uno, falsus in omnibus is not applicable in prevalent system of criminal administration of justice, and more so there is no rule having universal application that where some accused persons have not been found guilty, the other accused would ipso facto stand acquitted because the court has to sift the grain from the chaff. If any authority is needed, reference can be made to cases titled Riaz Hussain versus the State 2001 SCMR 177 and Samano versus State 1973 SCMR 162, Elahi Baksh versus Rab Nawaz and another 2002 SCMR 1842. It is well settled by now that the maxim falsus in uno, falsus in omnibus has no universal application, and it is bounden the duty of the court to sift the grain from the chaff. In this regard, reference can be made to Kheru versus State 1981 SCMR 1136, Umair Khayat versus the State 2007 SCMR 1296. This may be seen that in a case of joint liability, the court may, in the light of the rule of sifting the grain from chaff, give benefit of doubt to an accused, but his acquittal may not be relevant for determining the guilt of his co-accused, and court is not obliged to acquit all accused on the basis of a rule of falsus in uno, falsus in omnibus, which is not followed by the courts in Pakistan. Ghulam Mustafa versus the State 2009 SCMR 916. In our jurisprudence, it is by now well established that the legal maxim falsus in uno, falsus in omnibus is not a universal principle to be applied in all criminal cases. However, according to settled case law, there are exceptions, and if evidence on the record warrants a doubt in the credibility of such witnesses, then indeed their testimony regarding another set of co-accused is to be considered with caution and cannot be accepted without strict corroboration from other independent and credible sources. In this connection, reference can be made to the case of Muhammad Nawaz versus State 1961, 1969 SCMR 132, Shafu versus State 1968 SCMR 719, and Allah Ditta versus State PLD 2002 SC 52. Hadim Hussain versus the State 2010 SCMR 1090. In fact, a futile exercise appears to have been made to press into service the doctrine of falses in uno, falses in omnibus, false in one thing, false in all, which is admittedly not applicable in prevalent system of criminal administration of justice. And more so, there is no rule having universally applicable that where some accused were not found guilty, the other accused would ipso facto stand acquitted because the court has to sift the grain from the chaff. Samano versus State 1973 SCMR 162. There is no cavil to the proposition that the rule that the integrity of a witness is indivisible despite its moral virtue has not been endorsed by the superior courts of this country without reservations and cannot be accepted as one of universal application. In the last analysis, as stated in some of the eminent judicial decisions, the grain has to be sifted from the chaff in each case in the light of its own peculiar circumstances. Riaz Hussain versus the State 2001 SCMR 177. Muhammad Zaman versus State 2014 SCMR 749. Mere acquittal of some of the accused statedly involved in the commission of crime by the trial court by extending benefit of doubt to them will not demolish the case of the prosecution as a whole against the remaining accused, as the legal maxim falses in uno, falses in omnibus will have no application in such circumstances. Muhammad Rahil alias Shafiq versus the State PLD 2005 SC 145. Apart from that, the principle of falses in uno, falses in omnibus is not applicable in this country on account of various judgments rendered by this court in the past, and for this reason too, acquittal of the 5 accused of the appellant has not been found by us to be having any bearing upon the case against the appellant. Muhammad Afzal versus the State 2017 SCMR 1645. We are mindful of the fact that principle of falses in uno, falses in omnibus is not applicable in our system of administration of justice relating to criminal cases, and the courts are required to sift grain from the chaff in order to reach at a just conclusion. But it is well settled by now that if some accused are acquitted on the basis of same set of evidence, the said evidence can be believed to the extent of the other accused facing the same trial. But the courts have to be at guard and are required to look for corroborating evidence for maintaining conviction in such like cases. Munir Ahmed and another versus the State and others 2019 SCMR 79. By now it is well settled that principle of falses in uno, falses in omnibus is not applicable in our system designed for dispensation of justice in criminal cases, and courts are required to sift grain from the chaff in order to reach at a just conclusion. Para 14. It has surprised us to notice that the only case in this country in which some reasons had been recorded for holding that the rule falses in uno, falses in omnibus is not to be applied was the case of Ghulam Muhammad and others versus State PLD 1951 Lahore 66, wherein Muhammad Munir CJ had built an argument around the tendency in witnesses in the province of the Punjab to mix truth with falsehood. In the said case, no such tendency in the other parts of the country had been mentioned, but in all the later cases the scope of the observations made by Muhammad Munir CJ had been extended to the rest of the country as a matter of course and without any discussion at all. Apart from that, Muhammad Munir CJ was of the view that the job of a judge was to discover the truth, whereas in our system of criminal justice discovering the truth is the job of the investigating agency, and the judge is to decide as to whether the allegations being leveled against an accused person have been proved by the prosecution in accordance with the law or not. Such blurring of the distinction between the jobs of an investigator and a judge in the reasoning of Muhammad Munir CJ had remained unnoticed in all the subsequent cases on the subject. This said obscurity has unfortunately gone a long way in distorting the criminal jurisprudence in the country, besides demeaning the virtue of truth and corrupting the sacred concept of justice by extending a license to witnesses to tell lies and reducing the judge to a lie detector sifting grain from the chaff and looking for a reason to convict an accused person on the basis of statements of witnesses on oath or solemn affirmation, which statements have been established to be not the truth, the whole truth, and nothing but the truth. Let me read this paragraph again. The said obscurity has unfortunately gone a long way in distorting the criminal jurisprudence in the country, besides demeaning the virtue of truth and corrupting the sacred concept of justice by extending a license to witnesses to tell lies and reducing the judge to a lie detector, sifting grain from the chaff and looking for a reason to convict an accused person on the basis of statements of witnesses on oath or solemn affirmation, which statements have been established to be not the truth, the whole truth, and nothing but the truth. Perjury is a serious offence in Pakistan. The Pakistan Penal Code 1860 PPC contains many offences dealing with perjury and giving false testimony. It is paragraph 15. The very fact that there is a whole chapter numbered 11 dedicated to such offences amply testifies to the fact that methods relating to giving of testimony were taken very seriously by those who drafted the PPC, and their continued retention in the PPC ever since reflects the will of the legislature, which is the chosen representative body of the people of Pakistan, through which they exercise their authority within the limits prescribed by Almighty Allah. The following sections listed under chapter 11 titled of false evidence and offences against public justice highlight the fact that giving false testimony has been treated to be a very serious matter entailing some serious punishments. 191. Giving false evidence. Whosoever being legally bound by an oath or by an express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement which is false and which he either knows or believes to be false or does not believe to be true, is said to give false evidence. 192. Fabricating false evidence. Whosoever causes any circumstance to exist or makes any false entry in any book or record, or makes any document containing a false statement intending that such circumstance, false entry or false statement may appear in evidence in a judicial proceeding or in a proceeding taken by law before a public servant as such or before an arbitrator, and that such circumstance, false entry or false statement so appearing in evidence may cause any person who in such proceeding is to form an opinion upon the evidence to entertain an erroneous opinion touching any point material to the result of such proceeding, is said to fabricate false evidence. 193. Punishment for false evidence. Whoever intentionally gives false evidence in any stage of a judicial proceeding or fabricates false evidence for the purpose of being used in any stage of a judicial proceeding shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. And whoever intentionally gives or fabricates false evidence in any other case shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. 194. Giving or fabricating false evidence with intent to procure conviction of capital offence. Whoever gives or fabricates false evidence intending thereby to cause or knowing it to be likely that he will thereby cause any person to be convicted of an offence which is capital by any law for the time being in force shall be punished with imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. If innocent person be thereby convicted and executed, and if an innocent person be convicted and executed in consequence of such false evidence, the person who gives such false evidence shall be punished either with death or the punishment herein before described. 195. Giving or fabricating false evidence with intent to procure conviction of offence punishable with imprisonment for life or for a term of 7 years or upwards. Whoever gives or fabricates false evidence intending thereby to cause or knowing it to be likely that he will thereby cause any person to be convicted of an offence which by any law or for the time being in force is not capital but punishable with imprisonment for life or punished with, or imprisonment for a term of 7 years or upwards, shall be punished as a person convicted of that offence would be liable to be punished. 196. Giving evidence known to be false. Whoever corruptly uses or attempts to use as true or genuine evidence any evidence which he knows to be false or fabricated shall be punished in the same manner as if he gave or fabricated false evidence. 197. Issuing or signing false certificate. Whoever issues or signs any certificate required by law to be given or signed or assigned or relating to any act, any fact of which such certificate is by law admissible in evidence, knowing or believing that such certificate is false in any material point, shall be punished in the same manner as if he gave false evidence. 198. Using as true a certificate known to be false. So whoever corruptly uses or attempts to use any such certificate as a true certificate, knowing the same to be false in any material point, shall be punished in the same manner as if he gave false evidence. 199 false statement made in declaration which is by law receivable as evidence, whoever in any declaration made or subscribed by him, which declaration any court of justice or any public servant or other person is bound or authorized by law to receive as evidence of any fact, makes any statement which is false and which he either knows or believes to be false or does not believe to be true, touching any point material to the object for which the declaration is made or used, shall be punished in the same manner as if he gave false evidence. 200 as using as true such declaration knowing it to be false, whoever corruptly uses or attempts to use as true any such declaration knowing the same to be false in any material point shall be punished in the same manner as if he gave false evidence. 201 causing disappearance of evidence of offence or giving false information to screen offender, whoever knowing or having reason to believe that an offence has been committed causes any evidence of the commission of that offence to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offence which he knows or believes to be false. If a capital offence shall, if the offence which he knows or believes to have been committed is punishable with death, be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. If punishable with imprisonment for life, and if the offence is punishable with imprisonment for life or with imprisonment which may extend to 10 years, shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. If punishable with less than 10 years imprisonment, and if the offence is punishable with imprisonment for any term not extending to 10 years, shall be punished with imprisonment of the description provided for the offence for a term which may extend to 1/4 part of the longest term of the imprisonment provided for the offence, or with fine or with both. 202 intentional omission to give information of offence by person bound to inform, whoever knowing or having reason to believe that an offence has been committed intentionally omits to give any information respecting that offence which he is legally bound to give shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. 2003 giving false information respecting an offence committed, whoever knowing or having reason to believe that an offence has been committed gives any information respecting that offence which he knows or believes to be false shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. 204 destruction of document to prevent its production as evidence, whoever secretes or destroys any document which he may be lawfully compelled to produce as evidence in a court of justice or in any proceeding lawfully held before a public servant as such, or obliterates or renders illegible the whole or any part of such document with the intention of preventing the same from being produced or used as evidence before such court or public servant as aforesaid, or after he shall have been lawfully summoned or required to produce the same for that purpose, shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Dishonestly, 209 dishonestly making the false claim in court, whoever fraudulently or dishonestly or with intent to injure or annoy any person makes in a court of justice any claim which he knows to be false shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. 211 false charge of offence made with intent to injure, whoever with intent to injure, whoever with intent to cause injury to any person institutes or causes to be instituted any criminal proceeding against that person, or falsely charges any person with having committed an offence knowing that there is no just or lawful ground for such proceeding or charge against that person, shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. And if such criminal proceeding be instituted on a false charge of an offence punishable with death, imprisonment for life or imprisonment for 7 years or upwards, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Holding that the rule falsus in uno, falsus in omnibus is inapplicable in this country, practically encourages commission of perjury, which is a serious offence in this country. A court of law cannot permit something which the law expressly forbids. Para 16 It can be seen from the analysis of the judgments mentioned above that the main reasoning given for not applying the rule relates to the social conditions prevalent in the country. It seems that because it was felt by the superior courts that generally witnesses testifying in criminal cases do not speak the whole truth and have a tendency to exaggerate or economize with the real facts, there is a danger of miscarriage of justice in the sense that a real culprit may go scot-free if a court disbelieves the whole testimony on account of reaching the conclusion that the testimony was false in some respect. With all due respect, we feel that such an approach, which involves extraneous and practical considerations, is arbitrary besides being subjective, and the same can have drastic consequences for the rule of law and dispensation of justice in criminal matters. Falses in uno, falses in omnibus Islamic provisions. 17. It was held in the case of Ghulam Sikandar Supra that expressed in a more direct manner a similar rule in the administration of criminal justice, which is a hallmark of Islamic jurisprudence, that when a witness has been found false with regard to the implication of one accused about whose participation he had deposed on oath, the credibility of such witness regarding involvement of the other accused in the same occurrence would be irretrievably shaken. Therefore, discussed main rule shall suffer serious change if and when it is examined in the light of the Islamic principles. Adverting to the Islamic principles relevant to the issue at hand, we note that the following verses of the Holy Quran deal with the matter of giving testimony. And do not mix the truth with falsehood, or conceal the truth while you know it. Surah Al-Baqarah, verse 42. And let not the witnesses refuse when they are called upon. Surah Al-Baqarah, verse 282. And do not conceal testimony, for whoever conceals it, his heart is indeed sinful. Surah Al-Baqarah, verse 283. O you who have believed, be persistently standing firm for Allah, witnesses in justice, and do not let the hatred of a people prevent you from being just. Be just, that is nearer to righteousness, and fear Allah. Indeed, Allah is acquainted with what you do. Surah Al-Ma'idah, verse 8. O you who have believed, be persistently standing firm in justice, witnesses for Allah, even if it be against yourself or parents and relatives. Surah An-Nisa, verse 135. So follow not personal inclination, lest you not be just. And if you distort your testimony or refuse to give it, then indeed Allah is ever with what you do acquainted. Surah An-Nisa, verse 135. And establish the testimony for the acceptance of Allah. Surah At-Talaq, verse 2. And we will not withhold the testimony of such as ordained by Allah. Indeed, we would then be of the sinful. Surah Al-Ma'idah, verse 106. And avoid false statements. Surah Al-Hajj, verse 30. And they who do not bear witness to what is false, Surah Al-Furqan, verse 72. From the above, it can be seen that giving testimony its due importance and weight is an obligatory duty, and those who stand firm in their testimonies are among the people of righteousness and faith. Among the necessities of faith is giving truthful testimony, even if against oneself or a relative. If there are no other witnesses that would enable justice to be done, and there is a fear that someone's right may be lost, it then becomes the individual responsibility of the few available witnesses to testify. Islam not only enjoins giving testimony, it also forbids concealing it, because concealing evidence is something that is disapproved in Islam and detested by nature. Giving false testimony has many evils, for it supports a falsehood against truth and promotes injustice and aggression against justice. It also effaces fairness and equity and poses a danger to public safety and security. Para 18. According to corpus of traditions of the Holy Prophet, peace be upon him, false testimony is one of the great sins, and the following ahadith demonstrate the significance attached to giving true testimony. It was narrated by Hazrat Anas radhiyallahu anha that the Prophet, peace be upon him, was asked about the great sins. He said they are: 1. To join others in worship with Allah; 2. To be undutiful to one's parents; 3. To kill a person which Allah has forbidden to kill, such as to commit the crime of murdering; and 4th, to give a false witness. It was narrated by Hazrat Abdullah radhiyallahu anha that the Prophet, peace be upon him, said, if somebody takes a false oath in order to get the property of a Muslim unjustly by that oath, then Allah will be angry with him when he will meet him. To testify falsely tantamounts the polytheism. It is mentioned in Tafsir Abdul al-Fatrazi that the Holy Prophet, peace be upon him, repeated said statement thrice and then quoted verse number 30 of Surah Al-Hajj, stating that and avoid false statement. Para 19. The offence of Qazaf. Enforcement of Had Ordinance 1979 deals with the offence of Qazaf, which has been defined by virtue of section 2 of the said ordinance as whoever by words either spoken or intended to be read or by signs or by visible representations makes or publishes an imputation of a zina concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation or hurt the feelings of such person is said, except in the cases herein after accepted, to commit qazaf. The Holy Quran, while dealing the offence of qazaf, ordains that, and those who accuse chaste women and then do not produce 4 witnesses, lash them with 80 lashes and do not accept from them testimony ever after. And those are the defiantly disobedient. Surah Al-Nur verse 4. And those who accuse their wives of adultery and have no witnesses except themselves, then the witness of one of them shall be 4 testimonies, swearing by Allah that indeed he is of the truthful. Surah Al-Nur verse 6. And the 5th oath will be that the curse of Allah be upon him if he should be among the liars. Surah Al-Nur verse 7. But it will prevent punishment from her if she gives 4 testimonies swearing by Allah that indeed he is of the liars. Surah Al-Nur verse 8. And the 5th oath will be that the wrath of Allah be upon her if he was of the truthful. Surah Al-Nur verse 9. The verses reproduced above highlight the importance Islam places on the requisite standard of evidence to be achieved. It can be seen that the Holy Quran puts a great emphasis upon the need to meet the requisite standard of evidence, so much so that for a person leveling the allegation of zina but not meeting the given standard, it not only provides for a penal punishment but also for withdrawal of such a person's civic right to give evidence in all matters of his life. Para 20. Article 2 of the Constitution of the Islamic Republic of Pakistan 1973 declares that Islam shall be the state religion of Pakistan. Clause 1 of Article 2 to 7 of the Constitution mandates as follows: all existing laws shall be brought in conformity with the injunctions of Islam as laid down in the Holy Quran and Sunnah, and this part referred to as the injunctions of Islam, and no law shall be enacted which is repugnant to such injunctions. According to Article 199 of the Constitution, any decision of the Supreme Court shall, to the extent that it decides a question of law or is based upon or enunciates a principle of law, be binding on all other courts in Pakistan. Declaring by this court that the rule falses in uno, falses in omnibus is inapplicable in Pakistan is enunciation of a principle of law and has a binding effect if inapplicability of that rule militates against the injunctions of Islam, and if such inapplicability cannot be enacted by the Parliament on account of its repugnance to the injunctions of Islam, then this court may not be in a position to introduce such inapplicability through an enunciation of a principle of law or to continue with the same anymore. A court of law cannot grant a license to a witness to tell lies or to mix truth with falsehood and then take it upon itself to sift grain from chaff when the law of the land makes perjury or testifying falsely a culpable offence. A court also has no jurisdiction to lay down a principle of law when even the Parliament is expressly forbidden by the Constitution from enacting such a principle as law. The inapplicability of this rule in Pakistan was introduced by Chief Justice Muhammad Munir in the year 1951 at a time when Article 2 to 7 of the Constitution was not in the field, but after introduction of the said constitutional prohibition and the enunciation of law by this lordship in this field, like the infamous doctrine of necessity introduced by his lordship in the constitutional field, may not hold its ground now, as already predicted and foreseen by this court in the case of Ghulam Sikandar Supra in the following prophetic words: expressed in a more direct manner, a similar rule in the administration administration of criminal justice, which is hallmark of Islamic jurisprudence, that when a witness has been found false with regard to the implication of one accused about whose participation he had deposed on oath, the credibility of such witness regarding involvement of the other accused and the same occurrence would be irretrievably shaken. The afore discussed main rule shall suffer serious change if and when it is examined in the light of the Islamic principles. Para 21, we may observe in the end that a judicial system which permits a deliberate falsehood is doomed to fail, and a society which tolerates it is destined to self-destruct. Truth is the foundation of justice, and justice is the core and bedrock of a civilized society, and thus any compromise on truth amounts to a compromise on a society's future as a just, fair, and civilized society. Our judicial system has suffered a lot as a consequence of the above mentioned permissible deviation from the truth, and it is about time that such a colossal wrong may be rectified in all earnestness. Therefore, in light of the discussion made above, we declare that the rule falsus in uno, falsus in omnibus shall henceforth be an integral part of our jurisprudence in criminal cases, and the same shall be given effect to, followed and applied by all the courts in the country in its letter and spirit. It is also directed that a witness found by a court to have resorted to a deliberate falsehood on a material aspect shall, without any latitude, invariably be proceeded against for committed perjury. The office of this court is directed to send a copy of this order to the registrars of, the registrars of all the high courts in the country, with a direction to send a copy of the same to every judge and magistrate within the jurisdiction of each high court handling criminal cases at all levels for their information and guidance. Asif Said Khan Khosa, Chief Justice, Madar Alam Khan, Mia Hail Judge, Sajjad Ali Shah Judge, Islamabad, March 4, 2019, approved for reporting. Arif. Thank you.